So, Prince Harry back in the news with his legal shenanigans. Actually, Dan did a really good video on this, so I thought, well, at least I can expand on that by talking about disclosure. Then he covered that. But at least I can talk about limitation, which he also sort of covered. But also, why does this tie into the post office? Because this gives me a good excuse to talk about disclosure obligations generally, because they are quite confusing. I mean, lawyers supposedly understand them, but one thing we've seen in the post office inquiry is perhaps they didn't. But first of all, what's happening with Harry? Harry, as you may know, is suing some newspapers for sort of breach of privacy because of phone hacking type things. However, in law we have a thing called limitation. You have a certain amount of time to bring a claim. We don't have a statute of limitations in criminal cases, unlike some jurisdictions. Although what we call summary-only offences, minor offences that can only be dealt with in the magistrate's court, actually they do have to be brought within, you have to lay the information, in other words, start the procedure within 6 months of the date of the offence. But for serious offences, there's no time limit. That's why we can prosecute people for sort of things that happened in the war. But in civil proceedings, the idea is that eventually people need to be able to get on with their lives without worrying they're going to be sued down the line. So, a standard limitation period for things like breach of contract, negligence, that sort of thing, that's 6 years. For personal injury, it's 3 years. For personal injury that occurs on a ship or an aeroplane, it's actually only 2 years, and that does catch a lot of people out. And when does that change? It counts up until the moment, if it's a ship, you step on the quayside, or if it's an aeroplane, you step off the steps or onto the sort of airporty bit properly. So if you feel yourself taking a tumble and you're not sure how long it's going to take you to bring a claim, try and do a dive for the quayside or off the top of the steps. For things like fraud and breach of trust, it's up to 12 years. So when does the time start running? The time starts running from the first date you could have brought the claim. So in other words, the first time you could have sued them. So to give an example, I lend you some money and I say, I won't pay him back in 12 months' time. And you don't pay me back in 12 months' time, but I don't particularly chase the debt or anything. If I don't sue you within 6 months, within 6 years after that date it was due, then I've lost the right to sue you. What if though I just lend you some money out of the goodness of my heart and I don't actually say when it's due back? In that case, I basically have an implicit right to ask for the money back at any time. But if I don't ask for the money back, the time doesn't start running until I do. So if I sort of go, hang on a minute, you haven't paid me that money back, I actually have to say, please give me that money back. And if you then say, well, no, then I've got the 6 years. So what's this in relation to Harry? Well, the argument is, he says, well, I only found out, because this is the other thing, you've got to know that you have a claim. This crops up a lot in the art world. Say sort of like looted art. During the war, your painting goes missing from your family. And then it turns up in 1946 in Switzerland and Baron von Julingscar suddenly puts it in an auction. But what if you don't know about this? This actually happened. Elizabeth Taylor, when she married Richard Burton the first time, her dad was quite a famous art dealer. And as a wedding present, he said, pick a painting. And she picked a particular painting, he bought it for her. Now it turned out that was actually looted art. It had been stolen by the Nazis during the war. But the family only found out decades later when they saw an article about this. It was actually after she died. And they said, well, hang on, that's our painting. But the court said, yes, but it's too late for you to sue, because at the time she was married, this was all in all the society pages that her dad had bought of this painting. So if you read all the society pages, you would have known about this. Because it's not when you do actually know, it's when you could have known. And the argument was, you could have known this from an earlier date. So I'm sorry, you're out of time. They have actually changed the law slightly now. In America, they introduced a statute that actually, when it came to Holocaust looted art, it actually said, we're going to extend the limitation period. So for a few years now, we're going to say, even if you were out of time, you can actually bring a claim. That period has passed now, but that was just one way around this. But this is what's happened in Harry's case. His argument is, I didn't know I'd been hacked until way after it had happened. However, the newspaper is saying, well, no, we think, because of what you were saying in your book about, you know, the harassment and the hacking and things, we think you knew earlier than this. And we suspect that you've discussed this with people. And if we can show that you actually knew you had a claim prior to the 6 years, then you're out of time, mate. So they have said, we want all your WhatsApp messages and text messages between you and your literary agent and your friends. And they asked them to search, because how disclosure works is, you must disclose any material that either undermines your own case or may assist the other side. And that's whether you're a claimant or defendant, which, as Dan says, it might seem counterintuitive. But, you know, the purpose of the law is, if you've got a real claim, you can bring it. But if you haven't got a real claim, it's cards on the table. And you can't sort of trick somebody by hiding evidence into bringing a claim or defending a claim on an untrue ground. So when it comes to disclosure, you provide each side, they swap a list, it's a disclosure schedule, and you say, here's all the material that we have that we think is disclosable. And then the other side have a certain amount of time to say, okay, here's a bunch of items we would like to either inspect or have copies of the following. And then you've got a certain amount of time to disclose that. You can also put on the form things like, here's a list of material we do have but we don't think it's disclosable. Say, for instance, you argue it's legally privileged or something like that. And you can also put and say, here's a list of things we did have but we no longer have them, or they're out of our control, or we've deleted them. When it comes to litigation, you can't just sort of go start deleting stuff because you think a case is, you know, on the horizon. So you can't say, oh, I think either I'm about to sue somebody, but there's something here that might undermine my case, say on limitation, or I'm about to be sued and there's a lot of evidence here that shows I did it. I think I'll delete all that. That's actually perverting the course of justice. This can apply in a criminal sphere as well. Let's say you're in a traffic accident and you delete your dashcam footage. That's a separate offence, and people do get done for that. They actually get done for attempt to pervert the course of justice for removing the dashcam footage. And it doesn't even matter if it's irrelevant or you're innocent, you're not convicted of the original offence. The fact that you tried to make it harder to prosecute you. And this can happen with any sort of destroying evidence after a fact. People have been done for sort of washing blood-stained clothing, disposing of weaponry, that sort of thing. And it doesn't have to actually be the offender. It's quite common for offenders' families, you run in from something, a big sort of like stabbing in the street and your mum washes your jeans, then she can get done for that. So in this particular case, the argument is Harry had some disclosable material showing, that may show that he knew about this beforehand. And when it comes to sort of, electronic disclosure, because you can obviously have tens of thousands of emails or text messages, you'll usually agree to search on certain parameters. In this term, they said they'd search on 47 different keywords. Now, people are always commenting that I always get things mixed up and get names mixed up and spell things incorrectly. Maybe that's my secret way, you see, that if I'm ever sued, people will search on stuff and they won't find anything because I don't know how to spell judicature, or even my own name at times. I actually did that. I've got a middle name that I never used. I got pulled by the police and they said that's my full name. And they said, "And how are you spelling that, sir?" And I went, S-T-E, oh, hang on, no, S-T-U. And it was like, yes. Do you have your driving license? So yeah, the court has expressed a lot of skepticism and said, well, apart from anything else, Harry himself did the disclosure exercise, and they're saying, look, you're paying highly expensive lawyers. They racked up £50,000 in costs doing the disclosure exercise. And they're saying, well, why did you do this bit yourself when you got your lawyers to do all the other bit? Because, they are more likely to know what is and isn't disclosable. There's nothing to say, if you're representing yourself, then you can do your own disclosure because you have to. A disclosure has to be proportionate. Like if you're just doing like a small claim, they'll probably say, right, each side just disclose the documents and evidence you're going to rely on at court. In a normal case though, they'll say, please disclose everything that may be relevant, but you don't have to start trawling through all your archives necessarily. But in big, like complex, expensive litigation, they might say it's a key to the filing cabinet order. In other words, you can just sort of say, right, you come in, here's the passwords, to the other side, you search for everything. And there are sometimes ways of getting independent third parties in. There's a thing called an Anton Pillar order. which is like the civil version of a search warrant. So you say, right, we're going to sue some people, but we think they'll actually destroy or hide all the relevant evidence. So before you issue the claim, you go to court and you explain why you think that will happen. You can't just speculate, you have to sort of put some evidence in to suggest that will then happen. But then before you issue, and you do that ex parte, you don't tell the other side, because obviously that would defeat the object, because then they just go, right, well, we'll just set fire to it all anyway. But then you get an independent firm of solicitors who specialise in this, and they literally just turn up with the court order on the doorstep of the other side, you know, whether it's their offices or their personal property, you know, their own houses. And they go in and they seize everything. But then they go through it and they go, what is disclosable, what isn't. So anything that's confidential or privileged, they will not then pass on to the claimant. So it's quite an onerous sort of draconian order, but it does happen. But yeah, in this particular case, the judge has just said, I'm finding it highly, suspicious that, you've chosen to do this yourself. So, matey boy, I order you to instruct your solicitors to do the disclosure exercise, and I want you to turn over basically all your communications devices, all your old encrypted hard drives which have suddenly turned up that you said had been lost. I mean, this is very much like the Rooney and Varney thing with the rather unfortunate where everybody either physically lost their mobile phone or lost the password to their phones or their computers. So I can see why the judge is sceptical, not suggesting Harry has done anything untoward. It may be after this exercise. It proves he knew nothing about it. But now the solicitors will do the exercise, and if there isn't something in there where he's saying even something like, I think I have been hacked, and he can, suspect which newspaper it is, then the argument will be, well, that's when you should have sued us from. You could have sued us from that day because you were on notice you had been hacked. So that would be the end of the claim because he would be out of time. I mean, there are ways you can apply to extend a limitation, but it is very, very difficult. Limitation also, if you're a minor when something happens, the time starts running from when you're 18. So you do have a bit of extra time in those circumstances. But generally speaking, the courts are very, very strict about this. I mean, people have lost out on really good multi-million pound claims just because they issued too late. And the argument the court says is, this isn't something that, because if you make a mistake generally, if you get something wrong in litigation once it's all kicked off, and your claim is struck out for something because you didn't file something in time or you're told you can't file certain evidence, you can apply for relief from sanctions. And relief from sanctions is, I mean, there is an official test which is all to do with you had a good reason for it, you acted really quickly to put it right and all that. In reality, courts tend to look at it and go, well, actually, is this just giving a windfall to the other side just because you made a mistake? But forget, if you're ever doing this in real life, forget all what the proper test is. It's something called the Denton test. Forget all that. Just go in there and fall on your sword and say, Your Honour, I just messed up. I just either forgot to do it, I put the wrong date in my diary, I meant to do it, I just slipped up. And especially if it's lawyers, I always say this, this is what your insurance is for, but just go in there and fall on your sword and say, our client should not suffer just because of our negligence. And yes, we do have insurance and they could theoretically sue us, but it's a lot harder to sue for loss of a chance because there's no guarantee you would have won the case. And solicitors also say, well, it was a rubbish case anyway, so even if we'd done our job properly, they would have lost. And it's very hard to test that because you can no longer have the trial. So that is one thing I always, for all you young lawyers out there, just go in and say, look, our client shouldn't suffer because of this. And also, apart from anything else, that avoids you getting the negligence claim. So it's in everybody's best interest. But do just, judges are human. A lot of them are lawyers themselves. They know people make mistakes. So just go in there and say, look, I'm, working a 100-hour week and I've not slept for 3 days. So of course I'm going to make mistakes. But when it comes to limitation, the argument is, well, we can't relieve you from sanctions because that's a judicial process. And we don't have any jurisdiction because the case hasn't even started. You failed at the first hurdle. This isn't a procedural step you got wrong. You just have no right to bring a claim because you left it too late. So yeah, there you go. I mean, one thing that actually, remember the Watergate scandal? There's a really interesting thing there because, of course, the evidence against Nixon were all the tapes. And at the time, there was a bit of a debate as to who had the IP in those tapes. Was it the president personally? because everything was recorded, and there was no obligation on a president to actually record everything. It was just something that was done for convenience. But did that belong to the president or did that belong to the nation? And Congress were trying to subpoena those tapes, and there was a big argument in Congress as to whether they had the power to do it. And one of Nixon's lawyers said, right, here's what you should do. Get the tapes and have a bonfire on the White House lawn and set fire to them before the subpoena arrives. Because until that subpoena arrives, you are under no obligation to preserve or hand them over. and that was his argument, that he should just front it out, because he thought a lot of people, because Nixon was more surprisingly popular, he said if you do that, a lot of people just sort of go, wow, he's certainly not taking anything from Congress, is he? So in the end, Nixon didn't do that, and they handed the tapes over, and that was pretty much the end of him, wasn't it? So there you go. I'm not suggesting you, by the way, do sort of burn any disclosable material on your lawn. So have I covered everything? So I was going to bring the post office, wasn't I? Because the same rule in disclosure applies in criminal proceedings, and the test there is the prosecutor, and this applies to private prosecutors as well, like the post office, must disclose any material to the defence that may help the defence or undermine the prosecution case. And the test is may, not will. It has slightly changed now, because now you have primary and secondary disclosure. In olden days, the prosecution had to hand over just anything that might sort of tick those boxes. Now, initially, they only have to put over what are called primary disclosure, which is just a few sort of basic things. And it can be things like, here's a list of all the people we interviewed about this offence, including, people who gave a description of the offender that doesn't match you. But now you only get secondary disclosure, which is all the other stuff, if you actually file a defence case statement. You don't have to, in summary-only offences in the magistrates' court, you don't have to say what your defence is. You can do, and if you do put in a defence statement, then the prosecution have to look again and go, well, now he's saying this, all this material we thought wasn't relevant, well, arguably it is. If he's saying, no, it's mistaken identity, I want you to provide me with a list of everybody you spoke to who described the offender. Something like that. In jury trials, in what we call indictable offences that end up in the Crown Court, you must serve a defence case statement, and if you don't do that, it is held against you. The court can say, well, members of the jury, you must bear in mind that now he's saying he's completely innocent, but he had a chance to do that ages ago. This is the first time we've heard of it. If you might think that's because he's just making his defence up now that he's heard the prosecution case. But that triggers secondary disclosure. And this has cropped up a lot in the post office inquiry, because there's all these things where they're saying, well, now they're raising the problems of the Horizon system. Because at first they're going, well, they're just saying they didn't do it. They're not saying it's anything to do with the computer system, so we don't have anything to disclose, because remember, our cases, Horizon works perfectly. And then they said, we say there is a problem with the system. We want any material you have that discusses whether there are any problems in the system. And of course, there was lots of stuff like that. And that is when all the lawyers started saying, well, remove that, let's not disclose this. And there's actually memos, all the emails have come out where they're saying, eventually we will have to disclose this, but let's sit on it for as long as we possibly can. Just because we don't want to encourage them, and we don't want other people to find out about it, because then everybody else who's defending one of these cases will start to ask the same questions. And that's a massive breach. I mean, failing to comply with disclosure is one of the most common reasons, first of all, for your claim or defence to be struck out. And it's also a contempt of court. And in criminal proceedings, it can be in civil proceedings, it can amount to an attempt to pervert the course of justice. And if more than one person is involved in doing that, then it's a conspiracy to pervert the course of justice. And that is really serious. I mean, like I say, I suspect, not naming any particular names, but it wouldn't surprise me if there are criminal proceedings arising out of the post office inquiry just because of the failure of disclosure. So there you go. So I've justified the clickbait by saying Prince Harry in the post office. As always, hope you found that vaguely useful, vaguely informative. I've forgotten the word I always say. Oh, vaguely useful, that's it. So yeah, and where am I today? I'm just up on the north coast again, because it's a nice, pretty day, so I thought I'd just come out, have a nice walk, and bash out a quick video for you. Oh yeah! And if you did find this vaguely useful, whatever, please consider liking, sharing, subscribing, and YouTubey type things.